The Federalists feared that the Jeffersonians were essentially French revolutionaries. They feared that Jefferson's sympathies for French revolutionary ideology would lead to the kind of mob tyranny that you got in France. The Jeffersonians, on the other hand, feared that the Federalists really wanted to reestablish a monarchy, the very thing we had overthrown in the Revolutionary War. The Jeffersonians feared a very strong central government, one that would crush the rights of individuals and would crush the authority of states, turning states into the functional equivalent of counties in places like Britain or provinces in other European jurisdictions. These were, by the way, serious issues. Now, both sides exaggerated the dangers from the other side, but there were real ideological differences. For example, over what the proper role of the federal government was and what its relationship to the states would be. The reason it was a real issue is this. The Constitution of the United States was different. It established an arrangement here in North America very different from anything that had been known prior to this, very different from anything in Europe, anything in England. Instead of vesting what's sometimes called general jurisdiction, that is plenary authority, in the hands of the central government, the central government was created as a government of delegated and enumerated and therefore limited powers. It had only the powers that had been delegated to it by the people through the mechanism, the instrument of the Constitution. No matter how good it would be for the national government to exercise additional powers, if those powers hadn't been delegated to the national government through the Constitution, the national government didn't have them. If the people decided that the national government should have them, that the national government needed them for the sake of the public good, they could amend their Constitution. The Constitution itself provided mechanisms, more than one, by the way, for amendment. But if the Constitution wasn't amended to grant the national government additional powers, the national government didn't have them. So where was general jurisdiction? Well, here was the new idea. General jurisdiction remained with the states. The states are governments of plenary authority. They exercise what, following the English common law tradition, we came in America to call police powers, the powers to protect public health, safety, and morals, and to uphold the common good. So by contrast with the national government, the states had whatever powers they needed to advance the overall welfare, so long as a prohibition of those powers hadn't been placed on the states by the Constitution. That was the setup. Now, this created the following dilemma and contest in our politics. Federalists wanted a stronger national government. They didn't want to overturn the idea of the national government as a government of delegated and enumerated and therefore limited powers. The question was, how much power? And how strictly should we read the delegation of powers by the Constitution to the federal government? In effect, Federalists like Hamilton, like Adams, in a more modest way, and like Marshall, wanted to read the Constitution in a way that enabled the national government to do some things that weren't expressly or explicitly granted to them to do. Jeffersonians were more than a little wary about that. They were concerned that what we had going on with the Federalists was a bad faith effort to, in effect, overturn, to reverse the constitutional settlement, and to establish the national government as, in effect, a government of general jurisdiction, exercising plenary powers, police powers. Loose constitutional interpretation would be the mechanism, the Jeffersonians feared, that the judiciary would use in order to overturn that constitutional settlement and expand the powers of the national government. So the Jeffersonians favored a very strict reading of the Constitution. So if a power wasn't really truly expressly granted, let's take, for example, the power to charter a bank or other corporation, the Jeffersonians said the national government can't do it, no matter how good it would be, even for the public weal, for the national government to do that. If the national government really needed that power, then the people could amend their Constitution to, for example, empower the national government to charter a bank. That was what the dispute was really about. And this is why the judiciary became such an issue. When Jefferson prevailed over Adams in 1800, the Jeffersonians feared that the Federalists, though defeated at the ballot box, would try to govern the country through the federal courts, since after all, the federal courts were entirely in the grip of members of the Federalist Party. Not only Adams, but Washington had been careful to appoint Federalists and only Federalists as federal judges. And so the Jeffersonians had ideas of things like impeaching some of those Federalist judges, especially those whom they regarded as especially partisan, or finding ways to prevent those federal judges who had been appointed but hadn't yet taken office from taking office. That's actually what gave us the case of Marbury against Madison. But it's important to see that there's a power struggle going on here, and that power struggle is a struggle over the nature of the federal government and what its role would be, and that in turn became a contest over the meaning of the Constitution. William Marbury was a Federalist. He was a loyal Federalist, a member of that party, and he was appointed to a judgeship, a Justice of the Peace position in the Federal District of Washington, D.C. And so he wanted his job. He had a patronage appointment. He was a member of the party. The party rewarded him with the judgeship. The party was happy because he would be a good Federalist judge, someone who would think the way Federalists think and probably rule the way Federalists would like him to rule. So he wanted his commission, which is what you need in order to take office. Now, before leaving office, the president had appointed Marbury to his position, and the Secretary of State, who happened to be a man named John Marshall, had affixed the seal to that commission. So Marbury had been appointed, his commission had been sealed, guaranteeing the authenticity of the appointment, but the commission had not been delivered to him. He didn't have physical possession of it. So when the Jeffersonians came to power, when Jefferson became president, and Marbury requested the delivery of his commission, the executive branch said, nope, we're not going to give it to you. We think since it hasn't been delivered yet, we have no obligation to deliver it. We have no obligation to make you a judge, and you're not a judge until the commission is delivered. So the technical legal question there was, does a commission become effective upon signing by the president and sealing by the Secretary of State? Or does it become effective only upon delivery? Jefferson's position was the undelivered commission was ineffective. Marbury had not been appointed yet as a Justice of the Peace in Washington, D.C., and he had no obligation, he being Jefferson, had no obligation to deliver the commission. He could either leave the position vacant or appoint his own person as Justice of the Peace. William Marbury decides he's going to bring a lawsuit. He's going to take them to court. He's going to go into court and request something called a mandamus. And what a mandamus is an order from the court ordering somebody, a government official, to do something that the government official has a legal obligation, an obligation under statute or under the Constitution to do. So Marbury went into the Supreme Court of the United States and said, Your Honors, I would like a mandamus, and the mandamus should order President Jefferson or the Secretary of State, James Madison, to give me my commission so that I can take office and begin sitting as a Justice of the Peace in Washington, D.C. So, of course, speaking for the Supreme Court, there were 5 members at the time. Marshall is the new Chief Justice. He himself was appointed right at the end of the Adams administration, like Marbury. But Marshall, of course, was appointed to a much higher office to be Chief Justice of the United States. Marshall gets the case, and he says, well, we have a question before us. The first question is Mr. Marbury validly appointed to a Justice of the Peace position by the fact that the President signed and the Secretary of State sealed the commission that appoints him? And the answer that Marshall gave was yes, he has a right to his commission. So the next question is, well, if he has a right, then is there a remedy? And Marshall concludes that, well, if there is a right, then in the nature of the thing, there has to be a remedy. A right wouldn't make any sense if there were no remedy. The concept of a legal right wouldn't make any sense unless you could do something to effectuate the right. Somebody could do something to effectuate the right. But then we get the rub. Then we get the third Marshallian question. Does this court have the authority to right the wrong, to issue the mandamus? And here Marshall says, well, no, we're not the right court. Mr. Marbury has come to the wrong place. We don't have jurisdiction. That's the technical legal word. We don't have jurisdiction to issue the mandamus that would grant the remedy to vindicate Mr. Marbury's right. Now, the question is, why don't we? And Marshall says it's because Mr. Marbury is asking us to exercise what's called original jurisdiction. That is, to be the court in which a particular case is initiated, to be what we sometimes call a trial court, as opposed to an appellate court. But, Marshall reasons, if we have original jurisdiction, it must be because we are granted that original jurisdiction by the Constitution or by a valid statute. Now, there's nothing in the Constitution that grants us original jurisdiction in a case like this to issue the mandamus that Mr. Marbury wants. There is a statute that, as interpreted by Marshall, purports to grant us jurisdiction, original jurisdiction in a case like this. But when we look at that statute, we conclude that it is not in conformity with the Constitution, because the Constitution itself decides when we, the Supreme Court of the United States, have original jurisdiction and when we have only appellate jurisdiction. And in this area, we don't have original jurisdiction. It's not been granted by the Constitution, which means we only have appellate jurisdiction. But Mr. Marbury's not here on an appeal. He's here in first instance. He's here treating us as a court of original jurisdiction. And since we don't have original jurisdiction, we can't write what I, Marshall, concede to be a wrong. We can't vindicate a right by providing the remedy that Mr. Marbury is rightly seeking. That is a mandamus. So, Mr. Marbury, you've just come to the wrong place. You're going to have to go somewhere else, to a court that exercises valid original jurisdiction. Now look at what Mr. Chief Justice Marshall has done here. It's very interesting. He has, in effect, proclaimed that he is a judge who will practice judicial restraint by refusing to exercise power that has not been granted to him by the Constitution, and that indeed it would be in violation of the Constitution for him to exercise. So this looks like a case of judicial abstention, judicial modesty, judicial stepping back and refusing to exercise power. And this is all the more dramatic because here he's refusing to do something in the interest of his own political party, the Federalist Party, on behalf of someone who's a member of the party who's got a patronage appointment and wants to take office with his patronage appointment. But what's really going on here? Let's have a closer look. While ostensibly declining to exercise power he hasn't been granted, exercising judicial modesty and restraint, he's actually asserting a grander, much more decisive and important power. That is the power to interpret the Constitution and declare an act to be unconstitutional, the act being the Judiciary Act of 1789, which, as interpreted by Marshall, would have, or purported to, confer original jurisdiction in a case like this on the Supreme Court. Now, why is that an issue? For this reason. Remember, the national government is a government of delegated and enumerated powers. The national government only has the powers granted to it by the Constitution, no others. It doesn't have plenary authority. And what is the Supreme Court a branch of? It's one of the three branches of the national government. So that means that the courts, the federal courts, the Supreme Court of the United States, like the executive and legislative branches, only has powers granted. But we can look from beginning to end through our Constitution. We can get out the most powerful magnifying glass. We can look at it under a microscope, and nowhere do we find the power of courts to invalidate legislation, the power of judicial review mentioned in the Constitution. So if it's not delegated, how can it be there? And yet Marshall has declared it's there, and we've got it, thus claiming for a court, for his court, a much greater, much grander power than the one that he is ostensibly declining to exercise, well, more than ostensibly, greater than the one he is declining to exercise, to issue the writ of mandamus as if he were a court of original jurisdiction. Now, what this means is that he's got the Jeffersonians in a trap. They hate this decision. The so-called Democratic Republicans, the Jeffersonians, hate this case, this ruling, because they fear above all else this power in the hands of judges who are overwhelmingly, virtually exclusively Federalists. This will be the power by which they rule from the bench. And yet, what can Jefferson and his party and his government do about it? Absolutely nothing. Absolutely nothing. Because all Marshall has effectively done is refuse to grant a Federalist the mandamus he requested. He seems to be acting against the interest of his own party and in favor of the Federalists. What's Jefferson going to do? Is Jefferson going to say, well, no, you really should grant this mandamus? Well, that would be the opposite of what the Jeffersonians want. It's the Jeffersonians, it's Jefferson himself refusing to hand Mr. Marbury his commission so that he can take his office. So it's a brilliant tactical move on the part of Marshall. He has the Jeffersonians in an impossible position. All the president, his cousin, second cousin, Thomas Jefferson, can do is steam and say, this is a horrible thing that my cousin John Marshall has claimed. This is unconstitutional. He's claiming that courts have a power that is nowhere mentioned in the Constitution. He's claiming that the courts have the power to override the will of the people as expressed through their elected representatives in the Congress, in, for example, enacting the Judiciary Act of 1789. But beyond talk, there's absolutely nothing that Jefferson can do about this. So Marshall has Jefferson in this case where he wants him. Now, of course, Marshall's not the first person to suppose that the federal courts and the Supreme Court of the United States have the power of judicial review. Even before the Constitution was ratified, Alexander Hamilton had claimed that implicit in the Constitution, whose ratification he was seeking, he's writing here in Federalist Paper number 78, Alexander Hamilton argues that implicit in the Constitution is the power of judicial review, although Hamilton says that the power by its nature could only be used sparingly. Alexander Hamilton, I think, had no idea of how important the power of judicial review would turn out to be and how easily abused it could turn out to be. But of course, the last person Jefferson is going to listen to as an authority on the Constitution is Alexander Hamilton. After Marbury, Marshall never again used the power of judicial review to invalidate a federal statute. Now, he did use the power to invalidate state statutes, but the Supreme Court of the United States would not invalidate another federal statute until 1857. In the worst possible case, in the case of Dred Scott against Sanford, the case that set the stage for the Civil War by, in effect, claiming that Congress lacked power to forbid the expansion of slavery into the federal territories. I think Marshall's decision in Marbury against Madison was correct. I think the power of judicial review is implicit in the Constitution. Alexander Hamilton was right about that. But the real question for me is, what is the scope of the power being claimed by Marshall in Marbury against Madison? And is that defensible? Here's what I think is defensible, and I think it's at least a credible reading of Marshall. And that is that the power of judicial review is the power of courts to decide for themselves what the Constitution means when it comes to the scope and limits of their own authority. But notice that that stops way short of saying that the power of judicial review is the power of judicial supremacy, the power of the courts not only to decide for themselves what they may constitutionally do and not do, but to bind other branches, the executive and the legislative branch, by their decisions. The legal scholar Robert Lowry Clinton, legal historian and legal scholar Robert Lowry Clinton, makes a pretty good case, in my view, for a modest claim on Marshall's behalf. He wasn't claiming that he could control the way the executive branch or Congress had to interpret the Constitution, but only that he could, or the court could, interpret the Constitution for themselves as to what they could and couldn't do. And after all Marshall did, technically or literally, was to refuse to exercise a power that he felt had been unconstitutionally conferred upon him by Congress in the Judiciary Act of 1789. He did not purport to bind the executive branch or to bind the Congress. It would be perfectly consistent with the ruling in Marbury against Madison for Marshall to hold that the executive branch must interpret the Constitution for itself with respect to its powers, and the legislative branch must interpret the Constitution for itself with regard to its powers. In other words, you could, if you read the opinion reasonably modestly, square Marshall's opinion in Marbury against Madison with Lincoln's view in criticizing the Dred Scott decision and saying that he would refuse to treat the principle of that decision as binding on the executive and legislative branches of government. Lincoln's position is sometimes called departmentalism. And as I read Marbury, and certainly as Professor Robert Lowry Clinton reads Marbury, that view is not ruled out by Marshall's decision in Marbury. The question is, does Marbury establish a fairly modest conception of judicial review as something implicit in the Constitution? Or does it establish judicial supremacy? Now, by judicial supremacy, I mean the power of the judiciary to decide what the Constitution means, not only for itself, but for the other branches of government, and to bind them by its rulings. The court itself does not declare itself to be supreme over the other branches, and does not declare its rulings to be absolutely binding on them, no matter what, until 1958. More than 100 years, 150 years after Marbury against Madison, 100 years after Dred Scott, when in the case of Cooper against Aaron, which is a desegregation case, 1958, the court says, we, the Supreme Court of the United States, are supreme in the interpretation, in the exposition of the Constitution. Well, what does the court cite as its support for that proposition? Marbury against Madison, and nothing else. No argument, no other cases. It simply cites Marbury against Madison as if it's obvious that Marbury against Madison stands not only for judicial review, but for judicial supremacy. Now that idea, I'm certain, is wrong. I'm certain that judicial supremacy is not consistent with the Constitution, and I suspect it's really not properly understood as what Marshall was claiming in Marbury against Madison. Thomas Jefferson, like a lot of other people, thought that Burr was not only a scoundrel, but a danger, and a danger to the country. that he was a megalomaniac, that he was a potential Napoleon, that he was just an all-around bad guy. And this was a young and vulnerable republic at the time. Its future was the reverse of clear. No one knew where this experiment in Republican government would go. Previous republics had all failed. And when they failed, usually due to faction, when they failed, they always ended up in the hands of a strongman, of a demagogue, of a power-hungry maniac. And Jefferson saw Burr as someone who might very well fit that role. And Jefferson wasn't alone in thinking that. Alexander Hamilton, who had no love for Jefferson and for whom Jefferson had no love, thought the same thing about Aaron Burr. Dartmouth College was a small college, but there were those who loved it. Dartmouth College was, as I recall, a college that was originally founded in part to educate the Native American tribes, the American Indians, to bring the blessings of Christian education to them. It was a missionary kind of a founding. The case ended up in as a contest between private authority, private corporation, and contracts that it entered into or was created on the basis of, and state power. And the upshot of the case is that contracts validly entered into that are not against public policy, that are not nefarious, that are not the fruit of duress or coercion or something like that, are sacrosanct. People have the right to enter into contracts, lawful contracts for lawful purposes, and when they do, the state cannot come in and overturn them or take things over or invalidate them. It's a sanctity of contracts principle. And this, I think, is something very consistent with Marshall's beliefs about the needs of the nation. Marshall thought that we needed a functioning economy, a market economy. It would be good for the country. It would be good for the general prosperity of the country. And if you're going to have that, you can't have political power being used to disrupt valid contractual relationships. Now, it would be one thing if the state were interfering with corrupt contracts or contracts that are against public policy because they're against public morals or against public health or for some other perfectly valid reason the state had good grounds for opposing. But you have an otherwise valid contract, it's not corrupt, not the fruit of coercion or duress, not contrary to public policy. Marshall's view was, if you want prosperity, if you want the functioning economy that will bring you prosperity, those contracts need to be treated as sacrosanct. Now, this is important because it tells us something about the relationship of the individual and the state, or more properly, the relationship between the state and civil society. Marshall's idea here is that the state, government, cannot exercise complete control of civil society. It can make rules under which institutions of civil society, like private educational institutions or families, can do business, can make certain rules, but it can't take over civil society or play the roles or usurp the authority or undermine the autonomy and integrity of institutions of civil society. That in a healthy polity, government would be limited. It would be strong and effective within its proper bounds, but it would be limited. The state can't just come in and take over a private corporation, for example. The Second Bank of the United States was the successor to the First Bank of the United States. The banks of the United States were chartered corporations. They were corporations, banks, chartered by the national government. Now, these were not purely governmental entities by any means. They were largely private. They would be what we might today call public-private partnerships. But they were chartered by the United States as opposed to the state of Virginia or the state of Massachusetts or some other state. They were controversial because, as you'll recall, the government of the United States, the central government, was not a government of general jurisdiction exercising police powers or exercising plenary authority. It was a government of delegated and enumerated and therefore limited powers, only given the powers that the Constitution conferred to it. Well, if we look at the Constitution, we do not see listed among the powers granted to the United States the power to charter corporations, the power to charter a bank. And so the Jeffersonians, Jefferson himself, those who favored a very limited national government, those who favored a strict reading of the Constitution, in part because they thought that strict reading is what we need in order to control the size and scope of the national government, opposed a Bank of the United States. Even at some times when Jefferson or the Jeffersonians believed that having such a bank would be in the national interest, they nevertheless held that it would be unconstitutional, absent a constitutional amendment adding a new delegated power, that is, delegating from the people through the Constitution the power of the United States to charter a bank. The Hamiltonians, the Federalists, favored a less strict reading of the Constitution, one that would make room for the national government to charter corporations like banks when it's in the national interest, when it's good public policy, despite the fact that there's not an express delegation of power. So that created the contest. The Bank of the United States, number one, in 1791, came into reality largely because George Washington favored it. It was hard to go against George Washington. People tried, but it was hard to go against George Washington. So despite Jefferson's hang-ups, you might say, his opposition to the chartering of a bank by the national government, the Bank of the United States came into reality and functioned from 1791 until 1811, when the charter expired, and the question was, would the bank be rechartered? Would we have a second Bank of the United States? Now, by this time, the Jeffersonians are in power. The 1800 election is long now in the past. We have Democratic, Republican presidents, and the question is, will we get a second bank? Well, initially, of course, we didn't. The people in power had been historically against the bank, and so they refused to recharter it until national economic problems, some of which, perhaps a majority of which, were connected to the debt we ran up in the War of 1812, caused even many Jeffersonians to change their minds and say, well, you know, we really do need this bank as a matter of public policy, so we'll avert our gaze or we'll hold our noses and we will permit a second bank to be chartered. But not all the Jeffersonians went along with this. I mean, some capitulated to what they regarded as just reality, that we really have no choice. Under our economic conditions, we're going to have a bank. It's very much to the economic benefit of the country and the government. But those who held out insisted that the bank was unconstitutional. And that's what ended up giving us probably Marshall's second most important decision, the opinion in the case of McCulloch against Maryland. Mr. McCulloch was the manager of the Bank of the United States branch in Baltimore, Maryland. He was also a thief who regularly embezzled from the bank, but lay that aside, that didn't figure in the case of McCulloch against Maryland. He ended up in court because he brought a lawsuit, and he brought a lawsuit because, on behalf of the bank, of course, he brought a lawsuit on behalf of the bank because the state of Maryland didn't like having the Bank of the United States in Baltimore competing with the state-chartered banks. And so they enacted a state tax that they imposed on the bank, on notes and paper issued by the bank, which put the Bank of the United States at a competitive disadvantage in that market. So Mr. McCulloch took time off from looting the assets of the bank to bring the lawsuit to get the tax declared to be unconstitutional. So the question before the court ended up being twofold. First, is it constitutionally permissible for the United States to have a bank in the first place, for the United States to charter a bank in the first place? The old question that had been around since 1791, when the first Bank of the United States was chartered, comes back now. And then the second question is, well, if it's permissible for the bank to exist at all as a federally chartered bank, can Maryland tax the bank? Maryland is, of course, not just an entity whose power is derivative of the national government, as a county would be in England, for example, or a province in some other country. It's a sovereign state. It's got sovereignty within its jurisdiction. It's got sovereignty within the scope of its constitutional powers, just as the national government has sovereignty within the scope of its constitutional powers. So can it, in the exercise of that sovereignty, tax this bank that's doing business in its jurisdiction? And Marshall addresses both questions. On the question of whether the Constitution permits the United States to charter a bank, Marshall, this won't be a surprise, after all, he was a pretty loyal and orthodox Federalist. Marshall decides that although the power isn't expressly granted to the United States to charter a bank or other corporation, it is implied by the Constitution. Now, here was his argument. Article 1, Section 8 of the Constitution lists the various powers that the United States is granted. For example, the power to raise armies and navies, the power to regulate commerce amongst the states, tax and spend, and so forth. But, Marshall says, to carry out those powers, you need other powers that function essentially as means to the ends that are in the form of the expressly mentioned powers, like the power to raise an army and navy or the power to regulate commerce among the states. And this debated power to charter a bank functions as one of those implied means, as a legitimate means of effectuating the other powers, the actual expressly mentioned powers. But, he says, we see this clearly as contemplated by the framers and ratifiers of the Constitution, because they include what's called the necessary and proper clause, sometimes called the elastic clause. It says that in addition to these expressly delegated powers, the United States shall have whatever other powers are necessary and proper in the carrying out of these powers. Well, read broadly, Marshall concludes, the bank is necessary and proper to the effectuation of the ends for which those powers have been delegated that are expressly granted. So with this pretty broad or loose construction of the necessary and proper clause, he gets to where a Federalist would want to be since 1791, and that is on the side of including among the powers of the national government the power to charter a bank. Hamilton saw this as important to his larger project of creating a national commercial economy. So that old debate that we learn about in school between Jefferson and the Jeffersonians wanting a more kind of rural, non-commercial, traditional economy, and Hamilton wanting a dynamic, modern commercial economy, we see it playing out here in the bank. Hamilton thought you needed the bank. The Federalists were all on board with that. You need the bank. But since the bank isn't mentioned, how do we read the Constitution to include the power to get a bank? And here the necessary and proper clause serves reasonably well for Marshall to reach that result. Now, the Jeffersonians are the strict Jeffersonians, those who hadn't capitulated under the pressure of what they regarded as just reality, the need for the bank as an economic matter. The Jeffersonians weren't buying this for a minute. They responded by saying, well, if you read the necessary and proper clause that loosely and that broadly, then there is nothing that would be out of bounds for the national government. The national government could do anything on the grounds that it needed to do whatever the unmentioned thing was to effectuate the ends for which the express powers had been expressly granted. And that's actually not a bad argument. Now, remember, we need to put ourselves in historical context here. We're way more than 100 years away from the rise of the administrative and regulatory state. We're talking about a much simpler set of economic circumstances here. Whether Marshall, even though he was a Federalist, would have been in favor of Wilsonian or Rooseveltian or Johnsonian, I'm referring to Woodrow Wilson and Franklin Delano Roosevelt and Lyndon Baines Johnson, regulatory programs, to the alphabet soup agencies, to the administrative state, is something that I think is not even worth speculating about. We have no way of knowing. These are two entirely different worlds. Interestingly, though, the justification for the expansion, the constitutional justification for the expansion of creation and expansion of the administrative state has not been via the necessary and proper clause invoking Marshall's opinion in McCulloch against Maryland, but rather under a broad and loose reading of the power to regulate interstate commerce, the so-called Commerce Clause or commerce power. But looked at in its own historical context, you see that Marshall was expanding, by use of the necessary and proper clause, the authority of the national government, not to create the administrative state, but still expanding the authority, with the Jeffersonians worried that there was no limiting principle possible here, that once you adopted that looser reading, that broader reading of necessary and proper, anything goes.
What does he decide on the power to tax the Bank of the United States, Maryland's power to tax it?
No one's going to be surprised that this very orthodox, loyal Federalist, John Marshall, decides not only that the bank is constitutionally permissible, but that the efforts of Maryland to tax the bank are constitutionally impermissible. And here he has an interesting argument, one that I think actually doesn't hold up logically in the end, but nevertheless, it was his argument. It prevailed. And this is the argument that, quote, the power to tax is the power to destroy. So if Maryland has the power to tax the national bank, it has the power to destroy the national bank. But that is a power that couldn't be legitimately exercised against the national government, which was, of course, supreme within its own proper constitutional sphere. So we can't permit the state to tax the bank. Moreover, Marshall makes what's sometimes called the parts and wholes argument, and it goes this way. The people of the United States, if they chose to say tax state banks, would include the people in the states whose banks are being taxed. They would have a say. There would be a kind of democratic validation of that decision. But when it's the reverse, when the people of a state are taxing the national bank, the people of the state are making a decision about the fate of the national bank without the participation of the people of other states. So the conclusion he draws from this logic is that while the federal government could tax a state-chartered bank, the states cannot tax a nationally or federally chartered bank. The state of New York wanted control over the regulation of steamboats in its waters. And it was in a position, therefore, to favor who it wanted to favor, which would, of course, mainly be in-state interests who had political power, could make a difference in the state's politics. I mean, this is the way democracy works. As Churchill famously said, it's the worst form of government except for all the rest. But the Constitution grants the power, expressly grants the power to the national government to regulate commerce among the states. And there's really no question that part of the reason for the addition of the commerce power to the list of delegated powers in the Constitution, this is a power that did not exist under the Articles of Confederation. The reason it's added is to avoid the kind of state favoritism that had occurred under the Articles of Confederation. to make it possible for a national economy to emerge. And Marshall and the other Federalists believed that we needed a national economy, flourishing national economy for the nation to flourish as a commercial republic, is the sort of thing Hamilton, the great arch-federalist, envisioned. So the idea that states would use political power in ways that would impede interstate commerce or impede the fair treatment of out-of-state corporations by in-state governments, by state governments, this was anathema to Marshall, and he had a constitutional hook, a pretty clear one here, in order to fight back against that, and he used it. John Marshall was one of the great men of American history. He was a patriot. He was a Revolutionary War fighter, a real one, saw combat. Someone who didn't have to sign up, but together with his father, Thomas, he did sign up. He served with honor and some distinction. And he came to believe, in part because of his war experiences, that we needed a reasonably strong national government to unite the American people. He didn't want to abolish the states. He did not want to overturn the delegated powers theory of the national government under the Constitution. But he did believe that the success of the country as an experiment in Republican government, as an experiment in ordered liberty, really did depend on there being a reasonably strong national government. And so he became a member of the Federalist Party, a loyal, orthodox member of the Federalist Party. After his service in the Army, became a lawyer of some distinction and success, made a good deal of money, represented some important interests. He was the second cousin of Thomas Jefferson, from whose opinions in politics he was very distant. Jefferson, of course, being the very opposite of a Federalist, the great nemesis of the Federalist. John Marshall was the eldest of 15 children, grew up on a farm. His family was of some distinction, although there was a scandal in the background on his grandmother, on his maternal side, with his maternal grandmother. Yet he pretty much made up for that with a very advantageous marriage into one of the great families of Virginia. Marshall had actually been born in Pennsylvania, but was moved with his family early on to western Virginia, northwestern part of Virginia, the mountainous part of Virginia, where his father farmed, and then started getting into business. Was a surveyor. His father was known to Washington. They did some surveying together, and Marshall, when he was in the Army, was assigned legal duties. He wasn't trained as a lawyer. He would later take some training at William and Mary in law, I think about a year or two. But he learned the way lawyers in those days tended to learn, by apprenticing, by doing actual legal work in the Army under Washington. And so he developed legal skills and something of a legal mind. He took to it very naturally. He was very good at it. Maybe there in the background is the fact that when his father was educating him, he only had about a year of school, but his father educated him at home very well, including by assigning him Blackstone's Commentaries on the Laws of England. So he was a legal natural. He was a kind of a legal star, and he rose up in the Federalist Party. He turned down several appointments, mainly governmental appointments, distinguished ones, mainly because they would have cost him money. He was making a lot of money and would have had to take a pay cut, and he decided not to do that until, I think, his first really significant office was when he became Secretary of State in the Adams administration. And then when the Chief Justiceship was vacant at the end of the Adams administration, Adams, recognizing the legal talent that he had in John Marshall, made the appointment of Marshall as Chief Justice. He was not the first Chief Justice. John Jay was one of the authors of the Federalist Papers, was the first Chief Justice. Marshall was the fourth Chief Justice, but he's called the Great Chief Justice because it was under his leadership that the court became a significant player in the American constitutional and political drama. He played a major role in building the court's stature and its authority. The court would not be anything remotely like what it is today were it not for the Chief Justiceship of John Marshall, which is not to say that he would approve of where the court is today or of the massive role that the court plays in American life. Can't help but think that he'd be rather shocked to see that the court had gone as far toward the exercise of legislative power as in fact it has over the years. Still, what I said a moment ago is true. The Supreme Court would be nothing like the important institution it is in our public life were it not for Marshall. I'd like to discuss with Marshall if I had him right here, or if I had him in my class. I like to bring in distinguished federal judges. I've even had a Supreme Court justice or two to talk to my students. And I'd love to have him talk about McCulloch against Maryland and the question of federalism. This is such an important part of the American experiment. When our founding fathers opted for a republic, which was by no means an obvious choice to make, some people wanted Washington to be king. Some people wanted a monarchy, and we had a darn good candidate in George Washington. If you're going to have a monarchy, it's hard to find a better monarch than a figure like George Washington, in part because he wouldn't want the job. He genuinely wouldn't want the job. That's the kind of monarch you want. But nevertheless, they opted for a republic. And when they did that, they knew that there were going to be real dangers. They were taking a chance. They were taking a risk. Republics had always failed. They'd failed in the ancient world. They'd failed down through the centuries when they were tried. They'd failed for a variety of reasons, many having to do with the tendency of people to break into factions. So if republicanism was going to work, we needed a new approach to it. You'll forgive me for using the phrase, a new science of politics. I'm quoting there. And our founding fathers decided there were some mechanisms that they could use to prevent the collapse of this new republic in the way that previous republics had collapsed into despotism, into tyranny, falling before demagogues and so forth. And two of the most important ones were structural constraints on power. One in the form of the separation of powers. So we have separate and distinct executive, legislative, and judicial branches. And the second, the division of sovereignty between a national government as a government of delegated and enumerated powers and state governments as governments of general jurisdiction exercising plenary powers, the so-called police powers. In his career on the court, Marshall handed down, resolved important issues, made decisive, fateful rulings that shaped the meaning of separation of powers and shaped the meaning of federalism. And I myself am particularly interested in the federalism question. What will the relationship between the national government and the states, between the national government and the states be? It's one way because of the rulings of Marshall. It could have been another way. And it would be fun if we had Marshall here with us to explore those options and to dig into the question, why did he want it to go this way rather than that way? It would be fun to challenge him on his parts and wholes argument or the logic of his argument against the power of a state to tax a federal bank in McCulloch against Maryland. And I can't help but think that someone with his wonderful, probing, playful in some ways intellect, I can't help but think that he would enjoy the challenge, that he'd love the cut and thrust of argument when it came to these important issues. And of course, I'd be fascinated to know just how far he wanted the ruling in Marbury against Madison about the power of judicial review to be taken. As I said earlier, I cannot believe that he would think that the opinion, the principle enunciated of judicial supremacy in Cooper against Aaron could be constitutionally defensible. But where would he stop? How broad would the power of judicial review, under his understanding, be? It's left somewhat in doubt in Marbury against Madison, All we know for sure is that he held that courts, Supreme Court of the United States certainly, have the power to interpret the Constitution and refuse to act on grants of jurisdiction that they believe are contrary to the principles of the Constitution. Whether he would have gone or how far he would have gone toward the idea that courts can bind other branches of government, I'm not completely sure, and no one can be. Would he have accepted Lincoln's view that the executive branch was under no constitutional obligation, in fact, quite the contrary, to abide by the principle held down, set forth by the court in the Dred Scott decision? For example, the principle that even free blacks cannot be citizens of the United States. That's what Dred Scott against Sanford held. Even free blacks cannot be citizens of the United States. Lincoln said, I will not treat that as a binding principle. And in practice, Lincoln issued passports to free blacks, treating them as citizens, patents, ordered the patent office to give patents to black inventors, treating them as citizens, in effect defying the Supreme Court, refusing to accept the principle of judicial supremacy. Would Marshall have been on Lincoln's side, or would Marshall have held that Lincoln had gone over the line? Where exactly would Marshall be? It would be wonderful to know. Marshall, of course, held slaves. He wasn't a big slaveholder. He had been a small slaveholder. There's some evidence that he was not himself pro-slavery. He would have liked gradual emancipation, like a lot of people who weren't abolitionists, and even some people who held slaves. I mean, even Jefferson himself knew it was wrong. Jefferson was a big slaveholder. So on the moral question, I suspect that Marshall would have preferred to see slavery gradually abolished and slaves gradually emancipated. As a Federalist, I think Marshall would have had no doubt about the power of Congress in the federal territories where Congress did have general jurisdiction to forbid the spread of slavery or to restrict the practice of slavery. Now, even Lincoln acknowledged under the Constitution, he was against slavery, but under the Constitution, Lincoln acknowledged that he had no power, Congress had no power to prohibit slavery or significantly restrict it within the states. And Marshall would have been on board for that as a constitutional matter, no question in my mind. Lincoln believed that the national government, Congress, did have the power to restrict slavery in the federal territories, however. And I think it's a pretty good bet that Marshall would have been with him on that, too. I think Marshall was basically right in what he saw the Supreme Court's role as being and his role as Chief Justice. I think Marshall made important contributions to the good of the country by the way he conducted himself on the court and the way he built the court into a significant institution in the constitutional system. Now, does that mean I think that every argument he made was valid or every case was resolved correctly? No. No. But who would agree with every decision of any justice? I think he was right to think that some measure of judicial review was necessary, was implied by the Constitution. I think he was right to be on Alexander Hamilton's side of that debate. If, contrary to what I suspect he would hold, but if he intended in Marbury versus Madison, as the Cooper versus Aaron justices thought, to establish judicial supremacy, then I would say he's clearly wrong about that. He should be on Lincoln's side. On that issue, I think Lincoln is right, and I would hope that Marshall would be with him. If Marshall weren't with him, then Marshall, in my view, would be wrong. I think it's hard for us today to get ourselves back into the situation in the early years of the Republic, from the Revolution through the 1800 election. It's hard for us to fathom we're the greatest power on earth, the greatest economic power, the greatest military power. We're now the only superpower. It's hard for us to imagine how precarious the situation of the nation was. Republican government had never worked anywhere. not for the long term. Republics had always collapsed into despotism. Strong men, demagogues had always taken over. Look at the Roman Republic collapsing into Caesarism. Many people thought this would be the fate of the United States, and it was far from clear that they were wrong. 1800, in that election, we had a live question about whether the Federalists would leave office, whether John Adams would yield the presidency to his enemy at that point, Thomas Jefferson. Adams and Jefferson had been friends earlier. They would later become friends again. But in the 1800 election, they were not only political rivals, they were bitter personal enemies. This is the first major case of a democracy facing the question of a transfer of power from one party to another party, one political party to another political party. It's easy for us to say, well, yeah, of course, that would go well, that would go fine. But it wasn't clear that that was going to happen, that the Federalists would say, oh, the election was valid, the election was fine, everything's fine, we're going to give up power and let our arch enemies, the Jeffersonians, who we think are French Revolutionary lunatics, take power in the country. And especially given the bitterness and personal rancor that we see in that election of 1800. But the nation was blessed, and we got through it somehow. But even then, it wasn't clear that Republican government was going to prevail. What is Republican government? Well, Lincoln famously talked about government of the people, by the people, and for the people. All government is government of the people. All good government, all decent government is government for the people. Even the rule of a benevolent despot is government for the people, that is in the people's interest. What makes something Republican government is that it's government not only of the people and for the people, but by the people. And the question is, could the people govern themselves? Or would they, through their factionalism or their decadence or their unwillingness to engage and listen to each other and treat each other as fellow citizens, would they permit Republican government to collapse as it had in every other previous attempt? Even then, we had the debate about slavery. I mean, it was there waiting for a civil war to happen. And we had various compromises, the Constitution itself being a compromise about slavery, in order to maintain unity so that Republican government could prevail, despite the differences about slavery. Men like Adams were anti-slavery. Hamilton was anti-slavery. Jefferson knew it was wrong, but he practiced it. Many people thought it was right. This was a big division in the country, but it was far from the only division in the country. There was a big division about what the future of the country would be like economically. There were lots of reasons to be concerned about whether this experiment, and the founders themselves conceived it as an experiment, would succeed. Experiments by their nature can fail. And there was an awful lot at stake. Lincoln captured this so beautifully when he said at Gettysburg that the real issue here is whether Republican government of the people, by the people, and for the people, would perish from what? The earth, not the North American continent, and maybe be tried again somewhere else. Lincoln saw that this was the last chance, that Republican government had so consistently failed from the ancient world to the then modern world, that if it failed yet again here in the United States, that people would, for the foreseeable future, write off Republican government as a noble but unachievable ideal, as a dream, that something that could not be brought into reality with us frail, fallen human beings who tended to be selfish and fall into faction and not tolerate other people and have these terrible disputes that keep us from recognizing each other as fellow citizens. The whole future of Republican government, not just the United States of America, that was at stake, that's for sure, but also the future of government by the people And the success of the American experiment is the hope of people for the future, at least those of us who believe in Republican government. We've shown that government, not only of and for the people, but by the people, can long endure. Now, having said that, if we look back at our founding period, if we look back at the election of 1800, we will recognize that things are never finally settled. Certainly in republics, things are never finally settled. You know, each generation has to do what the founding generation did. Each generation has to preserve Republican government. We're always at risk. Those constitutional principles are good: separation of powers, federalism, the idea of the national government as a government of delegated and enumerated powers, not a government of general jurisdiction, limiting power to protect the institutions of civil society, to protect individual rights. Those structural constraints we have in the Constitution to protect freedom, they're very good, they're very valuable. But they cannot do the job just by themselves. They are not a machine that will go of itself. Virtue of some sort, not perfect virtue, but some measure of virtue in the people is required. The people have to believe in those principles of the Constitution, those structural constraints. They need to be willing to live by them, the way the Federalists were in the end willing to live by those principles when they turned over power to the Democratic Republicans, the Jeffersonians, after the 1800 election. People need to be able to recognize each other as fellow citizens. When we failed to do that once before in our history, we had a civil war that almost proved the experiment to be an utter failure. And there's no reason to think that can't happen again. So we need to be vigilant, and we need to learn from mistakes that have been made, and we need to learn from the example of great figures like Washington, like Hamilton, like Jefferson, for all his flaws, still had greatness, and like Marshall.